with me. It's essentially the same class as I gave last March, but I've made some changes. But just to begin, my aim is to place Supreme Court decisions in historical context, their economic, social, cultural, and political context, to explain, I hope, where they came from and where they led. And the details of the court's decision-making processes are really important when they relate to the bigger picture. Today, we're going to talk about two cases that came to opposite conclusions on the same question of law, and that can be explained in the context of the explosive economic and social changes in the first half of the 19th century. Classes 2 and 3 are about slavery, race, and civil rights. Class 2 is on slavery and Dred Scott. Class number 3 is on Jim Crow, the end of Jim Crow, and Decum Brown versus Board of Education. And finally, the fourth class on October 28th is going to deal with the current court. I call it a libertarian resurgence because I think in some ways that's what it is, especially when you consider the three cases that I'm going to talk about. Heller versus District of Columbia incorporated the Second Amendment and reflected a political decision by the court to expand the rights of gun ownership. Obergefell is the marriage equality case. And then I'm going to do a pretty extensive examination of Citizens United and how corporations came to have constitutionally protected rights. To do 4 classes, there's just so many cases, there's so much to talk about. So Lois, there will be a second class, I hope. First though, I want to talk about something a little bit different. I've been asked a lot of questions since Justice Ginsburg passed away, and the Republicans in the Senate have committed to filling the seat possibly before a new president and Senate can either be elected or take office. So this is kind of the nitty-gritty of it. Article 3, Section 1, which establishes the federal judiciary, says that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. The judges, both of the Supreme Court and inferior courts, shall hold their offices during good behavior. Now that says two things. One is the writers of the Constitution did not decide how big the court was going to be. They left that to Congress because at the very beginning, they understood that the country would probably expand. Remember, the Treaty of Paris in 1783, which ended the Revolutionary War, provided that the United States got all the territory south of the Great Lakes and east of the Mississippi River, when in fact the existing states were all on the east side of the Alleghenies. And it was understood from the Northwest Ordinance, which the Confederation Congress adopted while the convention was going on, that there would be new states created out of this territory. And so they decided just at the very beginning, we're not going to fix the size of the court. We're going to let that have Congress do it. And to preserve what they thought, what they believed would be the independent judiciary, they provided the judges would serve for their lifetime. Because the English tradition was kings could remove judges. It happened frequently. Judge pissed off the king, he got thrown out. And sometimes even worse than that. So then Article 2, Section 2, which established the executive branch, among the president's powers, said the president shall nominate and by and with the advice and consent of the Senate shall appoint Supreme Court and all other officers of the United States. But Congress may by law vest appointment of inferior officers as they think proper in the president alone, in the courts of law, or the heads of departments. And for that reason, that's one of the reasons that you'll see frequently when they'll talk about the difference between some federal judges and Article 3 judges. To give you an example, bankruptcy judges are appointed by a commission, and it's essentially a civil service. They serve for 14 years, and they're appointed by the presiding judge of the district in which they reside. They're appointed by the district courts. That's an example of a non-Article 3 judge. Now, and then it says in Article 1, Section 8, which talks about the powers that are delegated to the federal government. These are the main sources of federal powers in this one section, that Congress shall have the power to constitute tribunals inferior to the Supreme Court. And that's why in 1789, when the government, one of the first things the new government did was it passed a Judiciary Act, which established a number of things. One, it's established the size of the Supreme Court, which would be a Chief Justice and 5 Associate Justices, a total of 6. And they did this in part because they divided up the existing 13 states into 6 districts. And each one of these judges would be responsible for a district. So you had most of the New England states in one district, New York and New Jersey were a district, Pennsylvania and Delaware and Maryland were a district, the 2 Carolinas were a district, and Georgia was a district. So you had it divided up this way. In 1807, the Congress expanded the Supreme Court by adding 1 more associate justice. So there'd be a total of 7. Well, one of the things that happened in those years is between 1789 and 1807, there were 4 new states had come into the Union. Vermont, Tennessee, Kentucky, Tennessee, and Ohio. And so they had to they created another district, rearranged the size of the districts, and appointed another justice. They also, you might think, well, maybe they did it because they recognized that an even number is hard. Except by 1807, as a practical matter, there had only been about 15 Supreme Court decisions given because the court wasn't very active at first. They have to wait till cases get there. And almost all of them were unanimous decisions. The idea of 5-4 decisions, or what we call very strong minority voices, is something that happened much later. During the first 50 years of the Supreme Court, the vast majority of opinions were unanimous, or very close to it. In 1837, the number was raised to 9. Why? Because between 1807 and 1837, another 9 states came into the Union. They made Louisiana, Mississippi, Alabama, Missouri, and Arkansas, Illinois, Indiana, Maine, and Michigan. And so all of a sudden you got 26 states to create districts, and you have a lot of unincorporated territories from Louisiana Purchase, so they needed more. Now, interestingly enough, you guys may remember in 1850, there was the Compromise of 1850. California came into the Union as a free state. And in 1859, Oregon came into the Union. And in Minnesota came in 1858. And California and Oregon were the only states on the West Coast. There was no transcontinental railroad yet. That didn't come till 1869. And they realized they had to create a district to cover California and Oregon. So they raised it to 10. And a guy named Stephen Field, who was a justice on the California Supreme Court, was appointed by Lincoln. He was a Union Democrat in California, to the court. And by the way, Stephen Field is a fascinating character. If you ever want to read anything about him, I can give you the title of some books. He lived a fascinating life, and he served on the court for 34 years. At the time he left the court, he was the longest serving justice. He beat Marshall's record. In 1866, after the Civil War, Congress passed a law to reduce the court actually to 7 justices. That's why I made a typo there, by attrition. And the reason they did this was they were having the Congress in 1866 was literally at war with President Andrew Johnson. Remember, they tried to impeach him in 1867. And the idea was by doing this, they would prevent him from appointing any justices. So they, in 1866, the court was going to be reduced to 7, simply to prevent Johnson from appointing anybody to the Supreme Court. Now, in 1869, Ulysses Grant is president. That's not a problem anymore, so they immediately go back to 9 justices. Again, because now that they've got the Transcontinental Railroad, they don't need the 10th justice, and they recognize that an odd number is best. So that's where things have stood, and there'd been no changes in the amount, the size of the court since 1869. But there's nothing in the Constitution that fixes it at 9. Now, a lot of us, we're not old enough to remember actually, but I'm sure we all read about it, was in 1937, Franklin Roosevelt wanted to pack the court. It's the court packing plan. What had happened was this: between 1933 and late 1936, the court's conservative majority had struck down as unconstitutional the major New Deal legislation, including the National Recovery Act and the Agricultural Adjustment Act, a Bankruptcy Reform Act, and a Railroad Pension Law. Almost the four of the pillars of the New Deal. And FDR was upset because there were vacancies in his entire first term. So in early 1937, he proposed the Judicial Procedures Reform Act. And one of its key provisions was to allow the president to appoint 1 new justice for each existing justice who was over 70, up to a maximum of 6. Now, he had an ally, and that was the president, the majority leader in the Senate. But his own vice president was against the plan. That was John Nance Garner. Many of the Southern Democrats and most of the House was against it. But he did have the support of the Senate majority leader. And he introduced the bill in the Senate and to bypass the House because the Speaker was against it. And in March 9th, 1937, FDR gave a fireside chat to try and sell it to the American public. And he did so on the grounds that the Supreme Court they were too old, there were too many cases, there were delays, they didn't take enough cases, and that from an administrative point of view, Americans should have a more active Supreme Court. Well, the Senate Judiciary Committee held this up for 137 days. They just wouldn't vote on it. In the meantime, some developments in the court really changed things. One of them happened within a month of the fireside chat. There was a case that came before the Supreme Court called West Coast Hotel versus Parrish. And the issue in the case was, did the federal government have the right to set minimum wage laws? Now, Justice Roberts, who was the 5th vote that overthrew the NRA and that overthrew the Agricultural Adjustment Act, changed sides. He had previously voted against an earlier case that established minimum wages in a hospital in 1931, but now he switched sides. And by the way, it was called a switch in time that saved 9. Mm-hmm. You all ever want to remember that. Mm-hmm. Meanwhile, the Senate Majority Leader then dies, and in 1937, one of the judges dies, and FDR appoints Hugo Black. And the Supreme Court then upheld the National Labor Relations Act, it upheld the Social Security Act, it upheld the Farm Mortgage Act, and it upheld a revised Railroad Retirement Act. So most of the second New Deal legislation passed muster in the Supreme Court, which he did get 1 appointment. By the time the bill came to the floor of the Senate, it was amended to delete the Supreme Court packing plan and add some provisions that made it harder to get federal injunctions against collective bargaining. And so the bill passed both houses of the Congress, and FDR signs it. And it was deemed to be a political loss for Roosevelt because it was the first time a major initiative that he proposed didn't make it on what he thought was important. So while they say he lost it, but he really didn't, because between 1938 and 1941, a space of 3 years, there were 4 more vacancies. So between 1937 and 1941, FDR put 5 justices on the Supreme Court: Hugo Black, Felix Frankfurter, William Douglas, Franklin Murphy, and Harlan Stone. So that's the story of the court packing plan. And there's been no attempt to do anything since. And that's why we have 9 justices. And questions?
Okay, unmute yourself if you want to ask Arthur a question.
I'll go to stop share.
Okay.
There we go.
You raised hands here for questions.
Any questions? Any comments?
Pat, do you have a question? And unmute yourself.
I see there's one chat.
There we go. My question is, in what body reduced the court in 1986 to 7?
1986?
1866, I'm sorry, 1866, it was reduced to 7?
It wasn't reduced, it was to be reset at 7 as justices died. In other words, to reduce it by attrition.
Okay, what body in the government did that?
That was the Congress.
Congress, okay, thank you.
It was the Congress. Remember, by the middle of 1866, the Republican Congress was at war with Andrew Johnson over Reconstruction. Johnson had vetoed establishing the Freedmen's Bureau. He had vetoed a civil rights bill, both of which were passed by Congress overriding his veto. First time that had happened in American history.
Okay.
That a president's veto had been overridden. And Congress didn't want to give Johnson the ability to appoint new justices. So they said, okay, we're going to reduce the court to 7 by attrition, figuring that there's going to be an election in 1868. Johnson ain't going to win the thing. And that's what happened. Ulysses Grant won the election by a landslide. He gets sworn in March of 1869, because the election's in November of 1868. He's inaugurated in March of 1869. And the first thing Congress does was basically say, okay, it's 9. Yes.
Okay. Other
More questions?
Yes.
Yes.
I have one. So you were saying that at the beginning they represented areas, districts.
They still do.
They still do?
Yeah.
Districts.
Arguably, but now the circuit courts are so busy and the population's so big and the circuits are so large that basically the circuit courts are self-governing. Although ostensibly each Supreme Court justice is responsible for a circuit. And what you'll see is when cases come to the Supreme Court on writs, usually the first judge who will express himself is the judge responsible for the circuit where that case came from. In other words, to decide, are we going to grant cert or not? And he gets the first vote. Now, it's not any more important than the other vote, but that's in recognition of the fact that if the case came from California, then the justice who is in charge of the Ninth Circuit will be the first, will be the one responsible. And if it's like an emergency stay if there's an application for an emergency stay on an execution case, generally it's heard by the Supreme Court justice who's responsible for the circuit where it comes out of.
So if there were to be a stacking to happen, does that mean that the districts would be, they would actually create a new district or somehow?
Not necessarily. They could just, the fact that each Supreme Court justice is responsible for a circuit is a creature of law. I mean, that's Congress passed that. If you look at the slide, I'll go back to it. There's nothing in the Constitution that says that. That's all. The entire structure of the federal court system, other than the fact that there shall be a Supreme Court and such inferior courts as Congress may elect. It's all up to Congress.
Got it, thanks.
Yeah.
Okay, anything else? Okay, let me go back to share screen. Share. Okay. And let's continue. Now to the subject at hand. Let me, come on, how do I advance this slide while I'm sharing the screen?
Often if you put your cursor on it, maybe an arrow will appear or you.
Here it is. I got it.
Yep.
There we go. Now to the subject at hand. Let me start. I'm going to stop the share for a minute. Let me start with a couple of givens. I'm seeing Barry. Are you guys seeing me?
Yes.
Okay. If by politics we mean how men are governed, then all law is political, even more when it involves the state itself. So political and economic context is really critical to understanding. The two cases for today involve the Constitution's contract clause. In Article 1, Section 10, which talks about restrictions on the states, one of them is, and I'll read it out loud, it's very clear and very concise. It says, no state shall, blah, 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 pass any law impairing the obligation of contracts or grant any title of nobility. Well, forget the early grant. It's pass any law impairing the obligation of contracts. That is the federal question that the two cases I'm going to talk about were turned on. In 1816, the Supreme Court was not the institution it is now. During Washington's first term, it hardly said at all, as it didn't have any cases. The first Chief Justice, John Jay, quit after 5 years. He complained he was bored, he had nothing to do, and he decided that he wanted to run for governor of New York because that was an important position that he'd actually get to do something. The next one, John Rutledge, wasn't confirmed by the Senate, and the one after him resigned in 1800. He claimed bad health, but since he lived for another 15 years, it's much more likely that he hated Washington, D.C. If any of you saw the John Adams HBO show, they were pretty accurate on describing what Washington was like in the first 10 years of the Republic after it was started. By 1818, the court sat only for 4 to 6 weeks to hear arguments and render decisions. John Marshall, and let me go to share screen here. There we go. Was appointed by John Adams as Chief Justice a few weeks before Adams' term expired in 1801. Now, Marshall was a Virginian. He was a staunch Federalist. He had led the pro-ratification bloc in the 1788 Virginia State Convention that voted to ratify the Constitution. By the way, the vote was very close. It was like 78 to 75. Marshall, by the way, and Thomas Jefferson were first cousins, but they were not on good terms. There were political differences, substantial political differences, and there was a lot of personal animosity between them. Marshall had been very active during the Revolutionary War and had served in the Continental Army and participated in a number of battles. Jefferson was never in the Army, did not serve during the Revolution, and he was governor of Virginia at one time when John Burgoyne and a group of a British regiment invaded Virginia and marched on Richmond, which was the state capital. Rather than call out the militia, Jefferson split and went back to Monticello and actually went into hiding for a while so he wouldn't be captured because there was a price on his head. And Marshall thought he was a coward. So in any event, that's just a little aside on Marshall and Jefferson. Now, by all accounts, Marshall was a very collegial guy. When he became Chief Justice, he encouraged all the justices to stay in the same boarding house where they discussed cases over dinner. Now, the Supreme Court did not have its own facility. The building that we see as the Supreme Court building was built during the part of the WPA during the Depression. And I think it opened in 1938 or 39. They had to borrow a House committee hearing room in the Capitol building to hear formal arguments. They didn't even have their own law library. The story goes that the brethren, when they met, would drink wine only when it rained. But Marshall would look out the window on a clear day and said, our jurisdiction is very large, it's got to be raining somewhere, and order up wine for the group. Apparently, he was, everything that you read about from the contemporaries indicates that he was a very collegial guy, that most of the cases were decided by unanimously, and Marshall, who for 34 years wrote the vast majority of the court's opinions. Dissents were very rare. Okay, what's the main case here that we're going to talk about? It's Dartmouth, Trustees of Dartmouth College versus Woodward. It was argued in March 1818 and decided on February 2, 1819. It involved a dispute that arose in 1816. Dartmouth College was a small New Hampshire institution that was founded in 1769 by a man named Eleazar Wheelock to provide a Christian education for local Indians and to train them to be missionaries to their tribe. Let me go back here to the share screen. I wish this was easier to do. Okay, why is, here, that's right, here we go. There's Eleazar. The school was named for a British aristocrat, Lord Dartmouth, who had backed other schools that Wheelock had started. He called it this to try and get Dartmouth to put up the money for it. Now, Indians didn't rush to enroll, but the college did draw colonial students from the area. By the late 1770s, the student body was almost entirely Anglo, although it had accepted some African-American students, one of the first early colleges to do so. And one of its early alumni was Daniel Webster. Now, lawsuits always turn on underlying facts, and the case arose in the following circumstances. It was established in 1789 under a corporate charter as a, quote, body corporate by the New Hampshire Colonial Legislature that was approved by the Royal Governor of New Hampshire on behalf of King George III. The charter recited that the college's operations would be funded by private contributions. The charter named Wheelock president for life with the right to name his successor. The charter also created a 12-person board of trustees to oversee the college and its operations. Wheelock was allowed to appoint the initial members, but after that, they had the right to fill their own vacancy. So if any vacancy came up, the remaining members of the board would pick who would take their place of the departing or deceiving member. And although Wheelock had the right to, was the first president, had the right to name his successor, once he did so, the right to fire and hire subsequent presidents when Wheelock, subsequent presidents rested with the board. Now, when Wheelock retired, he named his son John to replace him. By 1815, John Wheelock, the president who was appointed by his dad, and the board of trustees could not get along, agree, or whatever, and he was fired. Just cause was not an issue. Now, whether at the urging of the ex-president for other reasons, the New Hampshire state legislature enters the picture. It passed laws that amended the original charter to reorganize the school as Dartmouth University. It expanded the board of trustees to 21, with the state legislature having the right to fill vacancies. It set up a new, totally new, 25-person panel of overseers with the power to veto the trustees' decisions. It gave the governor and the state legislature power to appoint new trustees and overseers. And in effect, the law converted the college into a state institution that ultimately was answerable to the state government. John Wheelock was then rehired by the expanded board. The named defendant in the case was a guy named Woodward. Who was he? He was the secretary treasurer of the college and the keeper of its records, including the charter and the seal. Now, he decided to keep his job, so he went with the new guys and took the records, the charter, and the seal with him. And this was important because whoever possesses the seal has the right to act on behalf of the corporation. It's kind of like this, the straw that's really important. Possession is 9/10 of the law, and if you got the seal, you got the corporation. The old board refused to accept these changes, and as, quote, Dartmouth College, they sued Woodward in New Hampshire State Court to recover possession of the seal and other records, which they had to do if they're going to establish control. Now, when they did so, the old board claimed that the New Hampshire legislators' actions violated the contract laws, that in effect, it was a state action that impaired the obligation of contract, Article 1, Section 10. The New Hampshire trial court and then the New Hampshire State Supreme Court ruled for the defense, and the old board appealed to the US Supreme Court. Now, when Congress set up the federal judiciary in 1879 under what it called the Judiciary Act of 1879, one of the provisions in that act said that the Supreme Court would have original jurisdiction to hear appeals from the highest state court in cases that turn on questions of federal law. Now, normally, the idea was if you have both a federal system and a state system, they operate independently. But Congress, when they set up the system, said, look, if it's a question of federal law, then we're going to give the Supreme Court the final say in it by giving them jurisdiction to take appeals from state courts on questions of federal law. And so the Supreme Court accepted the case for decision. Now, there's a political understory, as there is to almost everything. In 1815, most of the members of the Dartmouth College trustees were conservative congregational ministers and were Federalists in their policies. John Wheelock was Presbyterian and supposedly not an easy man to get along with. The New Hampshire governor and the vast majority of the New Hampshire legislature were Jeffersonian Republicans. They had absolutely no love for Federalists or a Federalist institution. And they were probably eager to take control of the highest educational body in the state. Now, Daniel Webster represented the old college and supposedly gave a long 3-hour argument. They didn't limit them to 30 minutes like they do today. In fact, some arguments went on for days. And supposedly he moved the justices to tears, talking about how about old alums need to preserve institutions, that they preserve memories, and really important. That might be nice hearts and flowers, but it has nothing to do with the main question. And the main question is this: was the New Hampshire law that annulled or amended the original charter unconstitutional under the contract laws? The court held that it was. Marshall wrote the opinion of the court, and Justice Story wrote a concurring opinion that I'll get to in a minute. Now, Marshall made 5 main points, and the first one is important. He said that the corporate charter granted by the government to private persons who want to form a corporation is a contract between the state, the entity that's created, and the entity's founders. Why is this a contract? He said it is because it has the elements of a contract. A meeting of the mind between the state as a party on one hand and the founder and those who contribute to it or buy the stock on the other hand. That there's consideration. In consideration for granting the charter, the corporation is going to fulfill the purpose for which it's created. And in these days, every corporation had to arguably fill some form of public purpose. And there was reliance that once the charter was granted, they took action, they raised money, they built buildings, and they operated under the rules of the corporation. Now, that's the first main point he makes, that a corporate charter is in effect a contract between the state and the corporation and its organizers. The second point he makes is even though the college provided a public benefit and served a public purpose, namely educating, it's still a private entity and it's not an arm of the state because the state is in the charter does not have any control. Marshall distinguished between public corporations and private corporations. A city is, and by the way, Santa Cruz is a charter city. It has a charter. Is a public corporation. Fannie Mae is a public corporation. Third point he made is once the charter is issued and the parties begin to carry out its function and act on it, the entity and those involved acquire rights capable of enforcement. In contract law, these are called vested rights. Let me give you an example. If you're selling, for anybody here's a realtor knows that when you sign a contract to buy and sell property, even if escrow is not going to close for 30 days, parties acquire rights under that contract according to its terms. It may involve for forfeiture or deposit if the buyer backs out. If the seller tries to back out, the buyer can compel for performance. So there's vested rights that acquire under the contract once it's made, even if the actions called for in the contract are to happen in the future. And so once the charter is issued and the parties begin to carry out its function, the entity and those have rights. These are vested rights, and it's this is what the Constitution was speaking to when it talks about states shall not impair the obligation of contracts. In effect, the state cannot, by its laws, impair vested rights that arise under a contract. And the vested right here is the right of the 12 trustees to operate the college under the terms of the original charter, including the right to fire the president after the first one and hire the presidents after the second one. Now, the framer, John, and the last point that Marshall made is that the framers included the contract clause to prevent states from violating the right to property. And he argued that this has been something that's happened before. Marshall's opinion notes that before the Constitution was drafted, a number of states passed laws that, in his words, quote, weakened the confidence of man in man and embarrassed all transactions between individuals by dispensing with faithful performance of obligations. In other words, Marshall claimed that some states had adopted measures that prevented creditors from collecting what was owed or enforcing vested rights that are created by contract. And the framers didn't want that to happen under the Constitution. Now that's the argument that he makes. Justice Story, probably the most scholarly justice, agreed, and he provided all the legal precedents. If you ever look at these opinions, you'll note that Marshall's opinion has almost no citations, and Story's concurring opinion is just full of them. But more importantly, Story told the states in the future how to bypass the restrictions of the contract clause. He said, look, if you enclose a provision in the charter that says the state reserves the right to amend this charter, the state legislature, or even more importantly, if the state passes a law that says any corporate charter granted after this law becomes effective is automatically subject to revision by the state, the problem is solved. The point is that because you can't do ex post facto laws, before a state did that, it stuck, Story's argument, it stuck with the charter as it's originally given, and the state can't change it without the consent of the parties. Now, this is one of the first instances where the Supreme Court ever overturned a decision of the highest state court on a condition of federal law. The second time it did it was in the famous case of McCulloch versus Maryland over the First Bank of the United States, but it came 2 years after this case. Was Marshall right on why the framers included the contract clause? Marshall and the framers understood that private economic relationships, debtor-creditor relationships, lien laws, enforcement of obligations, were issues that were normally decided by the states. There was no federal commercial law. This was always something that was clearly under state law. These were provisions that state laws and state courts decided. Now, only a few states had passed measures that afforded debtors a measure of relief before creditors could enforce judgments or liens on debtors' property. So let's say that he overstated the problem. There was more fear in terms of the contract clause. There was more fear of what states might do than discussed with what states had done. What literally, Marshall and the men who wrote the Constitution, most of whom were quite wealthy, had been literally freaked out by a populist uprising in 1786 of poor farmers in Western Massachusetts against both state taxes and court enforcement of taxes and creditors' liens. The uprising physically closed down local courts and physically prevented local officials from serving writs, etc. The movement was named after their leader, Daniel Shays, a former captain in the Continental Army, and was called Shays' Rebellion. Most of you have probably heard of this. The background to the Shays' Rebellion, understanding it in context of the contract clause, is really important. During the Revolutionary War, most of the armies, the federal forces, were state militias. The permanent army was much smaller, but every state had militias, and many of the states had their militias work with the Continental Army as part of it. And the states were responsible for supporting the militia. Further, it was the states that provided the wherewithal, the food, the clothing, the ammunition, etc., for their militias. So what Massachusetts did, as many states did, is it paid its militiamen and it paid the farmers and other tradesmen who provided goods and services, not with cash, because they didn't have any, but with IOUs that would be repaid when the war was over. But the men who received these IOUs needed money to support their families, to put in crops and pay taxes. So almost all of them sold their state issues IOUs to wealthy men who were willing and able to buy and hold them and accept the risk of non-payment. But the men who bought them, who bought the state's notes, wouldn't pay face value for them, and the men selling them needed a hard money to get by and weren't in any position to bargain. So the veterans, the families, the farmers, and artisans ended up selling their notes at a deep discount, often as low as only 10 to 20% of face value. Now, in 1780, Massachusetts had revised its state constitution, mostly written by John Adams, that heavily favored property interests. So in the 1860s, political power was consolidated in the Boston area where most of the state's richest men lived. They controlled the state legislature, and the governor was their ally. When the Revolutionary War ended in 1783, Massachusetts decided what to do. And the guys held most of it. And 35 of them held a third of the entire state debt. And these men had a lot of political influence. All of them either held positions in state government or had relatives who did. So not surprisingly, in 1784, the Massachusetts legislature voted to redeem in coin, hard money called specie, all of the state's IOUs at full face value with accrued interest. To do so, Massachusetts raised property taxes. Remember, there's no income taxes in these years on real and personal property. And because the state had to pay its debts in coin, taxes had to be paid in coin. Now, many of the poor farmers who couldn't pay their taxes, a lot of them borrowed money from money lenders to pay their taxes, but then they couldn't repay the loans. And if one couldn't pay on time, the state could file cases to collect taxes, or lenders could file cases to collect money that was owed and seize the debtor's property to pay the debt, to either pay his taxes or pay the debt. And for the state's poor to middling farmers at the time, the American economy's in the tank, especially for those in the western rural areas that didn't have access to the ports. Many of whom were veterans of the recent war didn't have any of the money. And in their eyes, the state government was in effect reducing them to abject poverty to make the richest men richer. So boom, an explosion of resentment in the backcountry known as Shays' Rebellion. Massachusetts raised several hundred state troops to put the rebellion down and restore order. The rich merchants, the state didn't have any money, so the rich merchants literally passed the hat and they raised the money to pay arm and support the troops. The rebellion was put down, Shays and 4 leaders were arrested, and the courts were reopened. So there's a direct link between Shays' Rebellion and the creation of our federal constitution and the inclusion of the contract clause. This is not something that's unrelated. There is a direct link to this. By 1786, which is when this took place, a number of colonial leaders had concluded that the Articles of Confederation were unworkable. Remember, the Articles provided that any action by the Continental Congress had to be approved by all 13 states, and the Congress had no power to enforce its decisions. It could pass a requisition for money, but it had no ability to force anybody to pay it. And so nationalists like Hamilton and Madison were prepared to curtail state power under a new national government because they felt that the United States was a canard. How can it make a treaty with a foreign power if it doesn't have the ability to enforce the treaty on the states if it called for payment of money, or if it called for certain things to happen, for goods to be coming duty-free or to be charged duty? Shays' Rebellion gave the nationalists the edge they needed. George Washington and others feared that the nation was in dire peril from the social unrest and a powerless national government. And Washington was so convinced that a stronger national government was necessary that he agreed to come out of retirement from public affairs to lead the Virginia delegation to the 1787 convention in Philadelphia. And his stature with all Americans provided more public support than the nationalists could have hoped for. Now, as for the contract clause, 30 of the delegates in the convention, which is almost a 2/3 majority, which is a majority of them, held $270,000 in state paper with a discounted value of only about $65,000. And they looked upon the states as a source of repayment and didn't want the states to renege. They didn't want the states to say, we don't have to pay that at face value, we only have to pay it at market value. So they threw in the contract clause. And by the way, so you'll know, the idea of having the federal government assume the state's Revolutionary War debt, for those of you who saw Hamilton, didn't come up till much later. So when they wrote the Constitution, they were thinking it's the states that are going to have to pay to repay all this. Marshall's opinion reflected the founders' position that preserving vested property rights was crucial to both liberty and economic growth. People needed to know that a deal is a deal, that states can't interfere with property rights based on the political winds of the moment. And such insurance was necessary, they believed, to induce investment, which was badly needed. And so they made it clear that the states can't be free to amend or change or cancel contracts where people have vested rights. Contracts properly concluded between free people not acting under duress must be protected from the power of the individual states. So that's the story of why the contract clause, and that's the first of the cases that I want to talk about today, that talk about how the Supreme Court takes on a state court decision and overrules it based on federal law, and what this federal law was and why it was important. Because what you're going to see when we get to, after the break, when we get to the next half of the case, is that a case that arose on almost identical interests came to the exact opposite conclusion. So I would suggest that we take a break and have either ask questions now or take a break and come back and ask questions.
Ron, did you have a question? I saw you had your hand up. That was from before. Okay. Anybody else?
I have a question.
Sure, Alice.
So I've been thinking as you've been talking that this is all about white men
You're
And-
absolutely right.
Okay, glad, I wanted you to comment on that, so yes, please.
Okay. The vast, first off, they did not consider Native Americans were part of the body or part of this, the social body. They were considered tribes. They were considered actually independent nations. They were not part. They were not taxed. Indians were not taxed. They did not. Their property was, there was no attempt to tax their property. They were not included. Most Indians, especially those that lived in tribal areas, were not considered part of the body. You're talking about the body. You're talking about a small population of white people. Women at this time were not considered political or economic individuals. The main law at the time was coverture. A unmarried woman's identity was subsumed, if she was a minor, was subsumed into that of her father. If she married, her economic and political identity was subsumed into that of her husband, who had control of all property in the family, as a rule. So you're really talking about you have an economy that is essentially designed for, run, and for the benefit of adult white men. The vast majority of African Americans at the end of the 18th century, about 1.5 million, were, the vast majority of them were slaves. The free black population was extraordinarily small, maybe 1 to 2% of the northern population. In some northern states, they were allowed to vote. Their property was taxed, but they were not. There's very little evidence. I don't think there's any evidence of any African American men serving in early state legislatures at the time, or if they did, there were so few that. This is not my area that I can speak on authoritatively, but I'm not aware of any. And so, yes, it was a economy, a political and economic environment that was designed for and to the benefit of adult white males.
And there were many of these, quote, minorities, unquote, that weren't even allowed to enter into contracts, correct?
Slaves were not. Free African Americans were in many states. Massachusetts, they were allowed to own property, and actually there were free blacks in the South who owned property, but they were not allowed to vote, and they were such a minority that their wishes, they didn't have what you would call political clout.
Thank you. That's helpful.
Anything else? Should we take a 5-minute break?
Okay.
Stretch our legs, get a glass of water, pit stop, whatever.
Okay, good.
Like I say, I'm not used to this Zoom thing. So it's 10:37, 10:57. We'll come back here about 3 to 4 minutes after 11.
Okay.
Okay?
Yeah, so I don't have the ability to unmute everybody. So if you wanted to say something, you can just unmute yourself as far as our chatting among ourselves here. Okay, what do we have here?
Good morning. It's Florence.
Hi, Florence.
Yeah, I just want to say, isn't it nice? We're meeting.
Yeah.
Yeah. Well, good morning, all.
Florence?
Yeah.
Hello, Florence.
Yeah,
I see you. She's my neighbor.
yeah. He's Art's my neighbor, and I see him walking, and we pass and say hi.
Usually with
Yeah.
my bicycle helmet on.
Yes,
That's
yes.
because the bike room in our apartment house is between my apartment and your apartment.
Yeah,
I see, Barry, I see there's one chat question here. Let me click on it, or it's gone now.
Well, there was one issue of just somebody's microphone wasn't working.
Oh,
Yeah, that's what it was about. And they got it to work. So
okay, just a minute
Yeah.
here. All of a
I'm
sudden,
going to mute myself.
I'm back in full screen and I don't want to be there, so. Well, no, that's not doing it. There we go, okay.
Very nice to have you in full screen.
I'm sorry?
Very nice to have you in full screen.
Oh, to have my, you know, to see my face?
Yeah, very good.
Whoops.
I have a rather petty question.
Yes,
In the courtroom scene that you showed us, there are two men leaning against a number of books. What are these books? Where the hell did they get them?
they're probably, the two men are probably clerks, the court reporter and the clerk.
Okay,
They don't have stenographers. If anyone's taking anything down, he's doing it by taking notes.
yeah,
And the
Like
book is
me.
probably, first off, this is a painting, not a photograph.
Mhm.
So
Yeah.
my guess is what you're doing is that the artist decided that, well, it's a courtroom and they're talking about law. We got to put some law books in the picture.
Thank you. That- yeah,
That's what I think it is.
okay, I'll buy into that.
But, you know, there were books, they had law books. You know, just about every lawyer had a copy of one book, Blackstone's Treatise on the Law, which was an English book written from
Yeah.
the 1750s, but it was the authoritative source of civil law that lawyers were trained in. Because remember, this is not far after the Revolution. One of the things that happened in 1800, when Jefferson took office in 1800, most American civil law, the law of private, personal, and economic relationships in the new United States, was very similar to what it was in England. Because the law was English law. Remember, during the colonial period, it was all English law. There were some differences that the states did for local, but lawyers were trained in English law. That was their training.
I see, yes.
And one of the things that happened between 1800 and 1845 is you see a change happen that literally transforms American law in a very transformative way. To give you an example, in English common law, in a contract, if you were trying to enforce a contract,
Okay, sweetie.
you as the plaintiff, I just lost your picture. Someone record, I guess someone's recording this.
I have it being recorded.
That's fine. If
Go on.
Okay, let me finish my point. Under English common law, if you wanted to enforce a contract, you had to prove the existence of the contract, and you also had to prove that the consideration that each side received was essentially equal. In other words, the party in trying to enforce the contract had the burden of proof, what they lawyers would call the risk of non-persuasion, to convince the judge that the contract was fair. By 1845, American courts were holding that once you prove the existence of the contract, that the consideration will be presumed, and whether or not the consideration was inadequate is a matter for the defense. So what in effect happens is that the idea of contract shifts from emphasizing the property, that the property balance in the contract was relatively equal or fair, to was there a promise being made? And if the promise was being made, then the presumption is going to be we're going to enforce the contract unless the defense can prove that for some reason the contract should not be enforced. It shifts the risk. Now, this is a fundamental change. English law didn't take this view until the 1860s. Give you another example. By 1818, the rule in most of the states was that corporate shareholders would not be liable for corporate debts beyond the value of their stock. That rule, we call that limited liability. That rule was not adopted in England until the 1850s. Give you another example is torts. Under English law, tort law was deemed a trespass. And the idea of negligence was not really at issue. If the injury happened and you could prove that it happened, then you owed. In other words, if you took an act on your property that caused harm to another person's property, whether or not you were at fault in that or whether or not what you were doing was proper or improper was irrelevant. You injured his property, you got to pay. By the 1850s, in America, most cases were developing a tort law based on the concept of negligence, foreseeability, and likelihood of harm. So you see this change happening in American law over a period of time. But at the time that this case is argued, especially in terms of procedure, English law is still very important. And most of the early state constitutions, including many of the state constitutions, provided provisions that said that the English law shall be the law, the English common law shall be, we're adopting as the law of this jurisdiction, except as it may be changed by state law or by state decisions. In other words, the idea was we're going to presume we're going to follow English laws, but judge, if you think there's a better idea, you don't have to. But there was a basic presumption that this is what lawyers learned. Okay, that's the end of that. That's kind of an aside, but I think it's fascinating.
I do too. Thank you.
So, Arthur,
Yes.
you made a comment earlier about how all laws are political.
You bet.
Can you expand on that a little bit?
Sure. If laws determine how we relate ourselves to how we treat each other, and if we define politics as the way human societies organize and govern themselves, then law is political. Because laws determine how we organize our society and govern ourselves. We can say when we adopt a rule that this is God-given, that this is natural law, and we accept that on faith. But that's really a cultural decision. It may be rooted in our culture, but it's a social construct. That's what I mean. All law is political, and you see this in the court because you see this all the time in the court. I'm getting ahead of myself. In the fourth class, the predecessor to Obergefell in 1960, shortly after Kennedy came on the court, he wrote a majority opinion that upheld a Georgia law that made homosexual sex between consenting adults in private a criminal act. 4 years later, he wrote a majority opinion that overruled his own opinion. Need I say more? Okay, Barry, I've got 8 minutes after 11. How many have we got here? Oh, we have 56 people. Welcome, everybody.
Yeah.
So, Arthur, I just wanted to say, good example. Thank you.
Okay. Okay, so let me begin by going back. In 1818, when the Dartmouth case was decided, the American economy was still relatively small. Transportation had not changed much since ancient times other than newly invented steamboats. Steamboats were invented in 1809 and were just coming into use, and many of them blew up. Just as an aside, one of the first set of state laws that regulated private commerce were rules that were designed to try and establish regulations that would prevent steamboats, boilers from exploding. Roads were horrid. It cost as much to send a ton of grain 30 miles over land as it did to sail it across the Atlantic. Agriculture was mostly subsistence farming communities where barter was the most common form of economic activity, especially for farmers who didn't have water access to coastal ports. Now, this is putting aside southern slave-based plantations, which is a totally different form of agriculture. But most northern agriculture was, especially if you got away from the coast or you didn't have downstream, a navigable stream that you could float your stuff to market. It was mostly subsistence farming communities where farmers, the most common form of economic activity was barter. So a guy who had 4 sons would trade his son's labor for clothing manufactured by his neighbor who had 3 daughters who stood at spinning wheels and could make shirts. And they would keep track. They would keep ledger books as to how many hours the sons would work, how many shirts they got, etc. But they were non-value-based exchanges. Manufacturing was still largely on the artisan journeyman apprentice system. It was low volume, high cost. Most manufacturing was conducted under one roof, and it was small. There was no mass production at this time. And commerce was very low volume proprietorships that dealt locally. So the Marshall Court, so that's where the Marshall Court was coming from. So let me go ahead. The next case is called Proprietors of the Charles River Bridge versus the Proprietors of the Warren Bridge. It was decided in 1837, 19 years after the fact. And so let me go here. Oh, I see it. Now you go to slideshow, play from current slide. And let me go forward to where I want to be. Okay, here we go. John Marshall died in 1835, and Andrew Jackson, then in his second term, appointed his longtime advisor, Roger Taney, to be the new Chief Justice. It's spelled T-A-N-E-Y, but we have it on good authority. He pronounced it Taney. Now, he was part of Jackson's kitchen cabinet of advisors. Jackson made him his Attorney General in 1831, moved him to head the Treasury in 1833. In 1834, Jackson nominated Taney to be an Associate Justice, but the nomination was rejected by the Senate, which was then controlled by the Whigs, who were led by Jackson's nemesis, Daniel Webster. There's a picture of him there too. Needless to say, Taney and Webster did not get along. There was a lot of animosity there. Marshall died in 1835, and Jackson nominated Taney to be the new Chief Justice. By this time, Jackson's party had won control of the Senate in the 1834 midterms, and Taney was easily confirmed as the new Chief Justice. I want to give a word on political context here. Jackson and Taney were of one mind on the interplay between government and commerce. In 1831, the national issue in the United States was over whether or not to extend the charter of the Second Bank of the United States. This was a bank that was organized by the federal government, to which the federal government would be the primary depositor. The bank was capitalized at $35 million, which made it 2 to 3 times bigger than the biggest second biggest bank in the country. And the stock was owned only 40% by the federal government and 60% by private individuals who invested money to provide the bank's capital. And Jackson and Taney hated the Bank of the United States. They thought it was controlled by moneyed interest and that its power over credit markets hurt the little guys. that they were out to make profits for the bank, many of whom, the shareholders of which were foreigners, because a lot of the money that capitalized it came from England, because American businesses were paying more than English were paying, the rate of return was higher. And the Whig-led Congress in 1831 voted to extend the charter of the Bank of the United States. Now, they did this for political reasons. There's an election in 1832. The Whigs believed that the bank was extremely popular because it regulated commerce. Commerce in the country economically was expanding. It was doing very well in the early 1830s. And they figured that either one of two things would happen. Jackson would sign the bill and recharter the bank, which would give them what they'd want, or he'd veto it and lose the election. Now, Jackson did veto it. Unfortunately, it didn't work out the way Whigs thought, because Jackson and his party won the election in 1832. But when Jackson vetoed it, he tried to argue it was unconstitutional, but the court had previously held that the Bank of the United States was constitutional. So the real reason he vetoed it was that he thought it was a bad law. And this was the first time that the president had ever vetoed an act of Congress simply because he disagreed with it. Jackson and Tawney believed that for most people, it was more important to provide access to opportunity than to invent property rights. And Jackson had Tawney write his veto message. And here it is. This tells you where Tawney is coming from, because it was written by him. It is to be regretted that the rich and powerful too often bend the acts of government to their selfish purposes. Distinctions in society will always exist under every just government. Equality of talents, of education, or of wealth cannot be produced by human institutions. In the full enjoyment of the gifts of heaven and the fruits of superior industry, economy, and virtue, every man is equally entitled to protection by law. But when the laws undertake to add to these natural and just advantages artificial distinctions, to grant titles, gratuities, and exclusive privileges, I'm almost going to underline that, exclusive privileges, to make the rich richer and the potent more powerful, the humble members of society, the farmers, mechanics, and laborers, who have neither the time nor the means of securing like favors to themselves, have a right to complain of their injustice of their government. And this was written by Tawney. That was firmly his belief. And so I give you that because I want you to know the context of his thinking when this case comes to the court. So here's what the case was about and how it was decided. The Charles River Bridge, let's see, laser color, red, here we go. Are you seeing me point at this bridge?
Yes, yes.
Okay. This first bridge here is the Charles River Bridge. It was incorporated in 1785 under a charter created by the Massachusetts Legislature to build and operate a toll bridge over the Charles River for 40 years. It was later extended to 70 years. So it's due to go 70 from 1785 is 1855. In the charter, the Charles River Bridge Company, who I'm going to call plaintiff, promised to pay Harvard University $20 a year because the bridge would replace a ferry that Harvard had operated since 1650. And obviously they did this because they felt that Harvard's ferry had a vested property right. And in order to get their charter, they promised that Harvard would be paid $20 a year to make up for their tolls. Now, the charter did not contain a specific promise that this would be the only bridge in the area. But it's safe to say that it was assumed because nobody's going to invest to build a bridge to make money by charging tolls if he knows that somebody else or the state at some time during the life of his bridge could build one right next to it that would be cheaper to use. So there's an assumption here. And this was very common at the time that this bridge is created. Many roads and most bridges and fords were granted privately. I'm going to bet right now that most of the 57 people who are signed into this saw the movie Lincoln. And you might remember a scene in the movie where this couple from Missouri come to talk to President Lincoln, because they have a Ford that was promised to them by John Quincy Adams that somebody is now competing with. And Lincoln says, I'm going to take this under consideration, but in the meantime, go tell your Congressman Beanpole, whatever his name is, that you're feeling that you'd like to see the 13th Amendment passed. I hope you guys remember that scene. Well, that's the idea. This guy had a ferry that someone was interfering with that was promised to him that he'd have the only ferry in this area. Now, in 1828, when there's still 20 years remaining or 30 years remaining under the Charles Bridges amended charter, the Massachusetts legislature grants a charter to incorporate the Warren Bridge Company. That's this bridge right here. The defendant to build another bridge connecting Boston to Charlestown. Now, remember, at this time, the Charles River, Boston is a peninsula. This whole area here that's called the Back Bay was filled in the late second half of the 19th century. If you go to Boston now, this is much narrower, and this is all filled in. It always blew my mind when I was a kid, and I see these early maps of Boston, and I've been to Boston. I had family there. Boston never looked like that. And the bridge, the Warren Bridge, was allowed to charge tolls for 6 years, but in 6 years the bridge would revert to the state and become free. So plaintiff sues the Charles River Bridge Company, sues the Warren River Bridge Company in Massachusetts State Court, alleging that the charter to Warren Bridge constitutes an impairment of contract and was unconstitutional, citing the Dartmouth case. It's the exact same. It's the exact same issue. By the time the case worked its way through the courts and up to the Supreme Court, it had been over 6 years, and the Warren Bridge was free and owned by the state. And Plaintiff's Bridge, which had another 20 years of life, lost its income stream because people wouldn't use it and pay tolls when they got a free bridge right next door. So the case comes to the Supreme Court, and Taney frames the constitutional question as whether incorporating a competing bridge constitutes impairment of contract when the charter of the first bridge did not contain an express promise of exclusivity. And Taney and the majority of the court held that it did not. And here's how we reasoned it. 1, the state is a sovereign entity, and granting charters is an inherent power of the sovereign state. And if it's an inherent power, they also have an inherent power to amend it if necessary to do so for the people's benefit. The state's powers are always to be exercised for the people's benefit. So unless the state specifically promised not to charter a competing bridge, it retained the right to do so. That's the main crux of his argument, that it's a question of interpretation, the meaning of a contract. And Taney cites as precedent English cases, which many existed, for the rule that any ambiguity in a contract is to be construed in favor of the party that drafts. Any ambiguity in a contract between the state and a private for-profit entity is to be construed in favor of the state, which stands in the shoes of the public. Now, 19th century common law, one, it's common to cite English precedents. And secondly, most contracts, if they're between private person A and private person B, and if one party drafts the contract and it's not, and there's no provision that says this contract is mutually drafted by both parties and shall not be construed for or against any party, which every lawyer puts in boilerplate in every contract today. The original rule was that contracts would be construed against the party that drew it. But if one of the parties was the state, the English rule was that any ambiguity shall be construed in favor of the state because the state stands in the form of the people. And so exclusivity is not imputed, implied, or assumed. Why? Because monopolies are disfavored. They impede progress, they impede competition, and they impede access to opportunity. And now this is why I take you back to what Tani wrote on the Bank of the United States, why that's such an important, how it relates exactly to this issue, to grant titles, gratuities, and exclusive privileges. It should be disfavored. So the decision holds that although the indirect impact of chartering the second bridge renders the first bridge's right to charge tolls valueless, it doesn't outweigh the public benefits. And I'm sure here the court's making this decision in part because you guys have had 50 years already of having this monopoly. It's time, it's over. The opinion argues that to find otherwise would retard both transportation improvements and economic both of which serve the public interest. Justice Story, who had been on the court when the Dartmouth case was decided, was the only member of this court in 1837 who was part of the Dartmouth court, dissented. He argued, hey, there's no difference if the impairment is direct as in the Dartmouth case or is a fully expected and inevitable consequence of the state measure. State court decisions and accepted legal scholarship at the time agreed that a state's sovereign powers included the power to grant a monopoly for the term of years to induce investment. And therefore, this right, this state, it's a contract right. The Charles River Bridge has a vested property right and the right to charge tolls for another 20 years, and your action is taking that right away from them, and the Constitution says you can't do that. And logically, it's pretty hard to see how Story is wrong. But the court isn't worried about logic. Marshall had been a nationalist and wanted to create a strong federal state. And in the political wars of the late 1790s and early 1800s, this is what was important. The project was to fix the federal government as above state law and to allow a broad reading of the Constitution and to apply it whenever there was something in it that could be applied, to apply it and give it precedent over state law. Taney and his fellow Jacksonians, on the other hand, wanted to create more opportunities for states to proactively engage in building economic infrastructures and to be more flexible. Now, again, we're talking about a national government that's basically, we're talking about adult white guys. That was their mindset. Now, the 1830s were a time of explosive changes in US economic life, not to mention changes in social, cultural, and political life. Let me give you some examples and comparisons between when the two cases were decided. In 1817, the population of the United States was about 8.2 million, of which about 3 million were slaves. In 1837, the population is 15.7 million, and about 3 million of those are slaves. There's been a transportation revolution. In 1825, the Erie Canal opened, connected the Atlantic seaboard to the Mississippi Valley by creating a water line of cheap water transportation that connected Lake Erie and to Lake Erie, the remaining Great Lakes. They were all at the same level, and to the upper Mississippi Valley, to the New York. It's the Erie Canal that made New York the financial capital of the United States and ultimately the world. Ohio, between, oops, I just did something wrong. My screen sharing, what the hell did I do here?
I think you just clicked off the ends.
There we go.
There you go.
Let me go back to slideshow from current slide. Okay, there we go. Like I said, this is my first time ever using Zoom as the presenter. Ohio, which is there in the lower right-hand corner, and you can drag your people to a different area or click and put them at the bottom, had 18 by had 814 miles of canals starting on the Ohio River, with 2 of them with outlets on Lake Erie. Rochester, New York, which was right here at the confluence of the Genesee River and the Erie Canal. Rochester did not exist in 1810. In 1821, its population was 1,500 people. In 1830, its population was 10,000 people. In 1840, its population was about 33,000 people. It was the fastest city growing in the United States. In 1818, the grist mills, Rochester was started because the Genesee River runs through Rochester, and there's a waterfall right in the middle of town. If any of you have ever been there, you've probably seen it. And of course, when you have a waterfall like that, that's a natural place to build mills that rely on water power, because the water's going pretty fast just before it gets to the falls. So you put a water wheel right next to it, you generate a lot of power. And Rochester became the center for wheat growers in the Mohawk River Valley to have their wheat turned into flour. In 1818, Rochester processed 26,000 bushels of wheat into flour. By 1828, the mills in Rochester processed 200,000 bushels. By 1839, 500,000 bushels. Ohio was the poster child of the transportation revolution. If any of you have spent any time there and driven across the state, you'll notice that the landscape really changes. Down around Cincinnati, where the Ohio River is, it's pretty hilly, but you move about 30 miles north of there, and the landscape really changes. Why? Because that's where the ice ages of the 4th ice age stopped. And so the ice ages really reduced all of Ohio, the northern half of Ohio River, to very gentle rolling land. Ohio, when it was the first state formed out of the Northwest Territory in 1803, it has about 60,000 people. By 1810, it had 230,000. By 1820, 580,000. By 1830, a little under 1 million. And by 1840, 1.5 million people. That's how fast the population growth was in Ohio. And this is not a farm state. It's 99%, adult white people. Look at this chart. It shows you how prices drop precipitously on transportation. We see this in canal rates, in river rates. So you literally have a transportation revolution. States are passing laws to promote and regulate railroads, banks, insurance. They're building canals, they're building roads. The early industrial revolution is well underway. It's the end of the artisanal system. By the 1840s, the factory system is definitely coming in. And you have social and political consequences. Products made in local shops and at home were being replaced by factory-made goods. One of the things, when I teach this class, one of the statistics that I'm able to show is that in New York, that you look upon the amount of homespun fabric that's being made, and that it reduces between 1810 and 1840 by 90% reduction. So you see this tremendous change in the way things are happening. And it's the end of the artisanal system, the rise of the factory system. Products made in local shops are much reduced. Consumer goods are becoming much less expensive. And so I think these two cases illustrate the political basis of constitutional law. The Dartmouth case, I'm looking at somebody's factor, beautiful red mark. I don't know whose sweater that is, but it's very pretty. The Dartmouth reflected the mindset and the recent memories of decision makers like Marshall and Story. They were anything but populists. They prioritized order, certainty, and predictability, especially in economic affairs. And they weren't that far removed in time from Shays' Rebellion and the Whiskey Rebellion of 1795. That's when farmers in Western Pennsylvania rose up in protest a federal tax on distilling whiskey by attacking revenue agents and the like. And they did so because in Western Pennsylvania, there was no access to markets. And in 1795, the only way a farmer could have any economic value out of his excess corn or wheat was to distill it into whiskey, which wouldn't rot, and it was a lot cheaper to transport. And the country was small. In 1818, there were only 18 states, the original 13 plus Vermont, Kentucky, Tennessee, Ohio, and Louisiana. 1837, all the founders had died. The US now has 26 states. The populist uprisings of the late 18th century, along with the Constitutional Convention, were in the distant past of memory. They weren't current. Jacksonian populism has ascended, at least for white males. And Taney gave priority to allowing states to have elbow room to grow their economies, to better the economic lives of their citizens, free of constraints of previous monopolies, even if created by contracts. Now, Taney wasn't the best Chief Justice we ever had, but were it not for his vision that the Union could only be preserved by protecting slavery and excluding non-whites, he wouldn't have gone down as the worst. Now, Taney had no one to blame but himself that his legacy is the Dred Scott case, and hardly anyone remembers anything else about him. But Taney was not just about the Dred Scott case. When it came to this issue, he was a believer in what you would call economic populism. He was a believer that states had a duty to try and create avenues of opportunity for the most people. And so that's pretty much why these two, and if you look at these cases, the issue is the same. Both cases involved a state action that impaired the vested rights of people that arose under a charter or a corporate charter that in effect is a contract. And in one case, it was upheld under the contract clause, and in the next case, it wasn't. And the only functional difference is that fortunately, there was someone didn't put in the first charter that no one was going to be build a bridge that competes with you, was not written in the charter. And because of that, it gave Taney the ability to disregard that rule and allow the second bridge to take effect and to give the people of the area a free bridge. And so that's these two cases. And that's my talk. So I will end my slideshow. And back to us. And I am now off sharing the screen, and I hope you guys can see me. Yep. Questions? The floor is open. Comments?
Well, okay, then I have one, Arthur. So as you mentioned before, you said all law is political, and I understand that, but also in principle, it's supposed to be based on precedent. So to what extent is precedent important? And this must have been somewhat complicated too in the early days in the court, where there just wasn't much of a record for US law per se.
Well, I'll give you an example. Precedent's important, but anytime you disagree with precedent, what do judges do? They look for a way to say that that precedent shouldn't apply here. And how do they do it? They always find a way to distinguish it on the facts. to say that the facts of this case are different. And if the facts are different, then that precedent shouldn't apply. And the one basic fact here that's different is there's no express comment of promise of exclusivity in the charter. Now, there's no exact promise of exclusivity in the Dartmouth case either, but it's that case not a competition issue. The Dartmouth case the rights have to do with the way the organization is to be operated, not with whether or not anyone's going to compete with it. That's one distinguishing factor. And the second thing that distinguishes it is there's no promise of exclusivity. And Tawny is saying that, hey, monopolies, yes, states can give them, but they have to do it expressly. We're never going to imply that there's a monopoly, because monopolies impair competition. They promise exclusivity to people who have the political clout to get it. Because remember, in these days, corporations themselves are political acts that require you to go to the state legislature and get the state legislature to pass a law that creates your charter, what is called private legislation. One of the things that happens after this case, starting in 1845, is that you see a movement to what are called general incorporation laws, where Louisiana is the first that in 1845 puts a provision in its constitution that says all corporations shall be passed under general laws. That they established a basis rule, a framework for apply that if you comply with A, B, C, and D, the state must give you a charter, corporate charter. And the state law says what those are. California adopts that in its 1850 constitution. It's the second or third state to do so. And by 1870, literally every state has adopted general incorporation. What this does is it democratizes the ability to be a corporation. And you see this change. Before the Civil War, there aren't that many corporations. After the Civil War, and I've looked at these statistics, it explodes. Ohio was one case in point. I think Ohio had a total of 300 corporations before the Civil War. By 1880, there's like 10,000 corporations in Ohio.
Okay.
And so what you see is so that's the context of this. And the context is critical. And I think if you look at courts, they will apply precedent, they will apply rules when it suits them. And if they feel strongly that it doesn't, they'll look for a way to get around it.
Okay, so I didn't see that Mark has raised his hand, and then there are two chat questions too. So Mark?
Mark?
Hi, Arthur. You gave some very interesting population statistics for the state of Ohio in the early parts of the 19th century. And I wanted to know how those are broken apart because, first of all, African Americans or slaves were considered 3/5 of a person.
Okay, first off, there's no, I'll get to the 3/5 rule in the next class, but no, first off, there's no slaves in Ohio. It's not
right,
a slave
but there are African Americans, and I just
there are, but it's a small percentage of the population,
right.
maybe less than 1%.
What about indigenous people?
What
was the population?
They're not, again, by 1840, if they're living in tribal areas, and the vast majority did, they're not counted.
They're not
because
counted.
they're not taxed.
They're not counted, not taxed. So that the actual population of the state could be considerably more.
Yeah, but it wasn't, because by this time there's Indian removal going on. And most of the vast majority of Indians have left. And again, the amount that's remaining is less than 1% to 2% of the entire population.
Okay, thank you.
Now, the German population is probably 40% of the state. In 1840, it speaks German.
Okay, so Garrett had a question on the bridge cases. So did Harvard continue to receive the $20 a year?
No.
Well, that's why they're so poor today.
Right.
So, Vivian, you had a question. You might unmute yourself and ask it, and then Gunther has one. Vivian? Well, anyway, Vivian question said, thanks, and can you spell out how this has changed leading to recent times? Or is that another 10 lectures? I'm not quite sure.
Well, the answer to the short answer is yes, it's another 10 lectures. But if you want a long answer, I can try and put one together. But I think it would probably take the next 20 minutes. That's really a hard question. One of the issues that we're going to come up with is the interplay of the 14th Amendment. Just to give you an aside, there's a case decided called Barron versus Baltimore in 1833. Pretty close to a unanimous opinion of the Marshall Court held that the Bill of Rights were intended to apply to the federal government. They were not intended to apply to the states, because in the First Amendment says Congress shall make no law. And so the court held early on that the Bill of Rights did not apply to the states. The 14th Amendment was adopted in the late 1860s. The main drafter of the first paragraph of it felt that he was trying to incorporate the Bill of Rights. The court didn't buy it, and it wasn't until the 20th century that on a selective basis, by the process known as gradual incorporation, the court incorporated certain provisions of the Bill of Rights were incorporated by the 14th Amendment to be applied, applicable to the states and all local governments. So you had free speech incorporated in the 1920s, religion in the 1930s, the criminal procedure provisions in the 4th, 5th, and 6th Amendment in the 1960s. And it wasn't until the 2000, after the Heller case and the Chicago case, that the Second Amendment wasn't made applicable to the states. So that's a whole nother story, but I'll deal with that in future lectures.
Okay, Gunther, you had a question?
Yeah,
And then Louis after that.
first I have a comment. When you look at the history of law, you have the American law, British law, and then a large portion of the British law comes from the Roman law, as I'm sure you know.
Right, well, and actually European law, that's why Louisiana is such a weird
Yes.
place, because it still had a lot of code law. But English civil law had moved very far away from Roman law, especially in the nature of law itself. Under Roman law, the idea was that statutes should be very broadly construed, and that court precedents were not as important as the broadest interpretation of the language of the statute itself. Under the British law, statutes were considered limited to specifically what they talked about, and courts were given free rein by precedent to interpret them, and it was up to the courts to decide what they meant. And those decisions would be precedents that other courts should follow unless they were clearly improper and could be explained why they shouldn't be.
Okay.
And so the common law system developed over centuries that made English law substantially different than Roman law. Although, the Roman, coverture and the divorce and marital property law retain much more of its roots, but
Right.
contract law and commercial law was substantially different.
Mhm. So when
Can I
you
intervene there for a moment? There seems to be some confusion. You can't talk about British law. English law is based on common law. Scots law is based, like Europe, on Roman law. They are different systems.
But then the Act of Union,
of law in that country.
Yeah, okay, except that since Scottish law only applied in Scotland, but it didn't apply in the colonies. British law applied in the colonies because Scotland was part of Britain. And I know you're from Scotland, and so you have a different take on it. But most people, especially the British, would say British law.
if they're talking law, they differentiate between English law and Scottish law. I'm
In
not
Scotland.
Irish. I can't comment on Irish.
Yeah.
Okay. Lewis?
Yes. Arthur, you painted a very beautiful picture of how things change over time. The technology changes, transportation, our market system, and issues change too. I mean, from militia issues to canal issues and so on. And so I have always thought about the Supreme Court justices, rather naively, I'm sure, but I've thought of them as being referees. I mean, we have our elected officials who reflect the changing times and can legislate to accommodate different problems that arise. But now I'm beginning to think that the court is not just a referee that looks at the Constitution, but they too are political people who wear robes. And so I wonder if this picture that you've painted of what happened between Charles River or Dartmouth and what happened at Charles River with all those changing conditions, have you seen over many decades since then a change in the nature of the court as going from refereeing into being politicians themselves?
I would say they've never been purely referees. I would say that the court has always been a political body, and that it just turns out in different ways. I'm going to give you two examples from modern life. They happened, two cases that were 2 years apart that dealt with this. You probably remember the Sebelius case, which upheld the Affordable Care Act. And Roberts wrote the main opinion. And in the main opinion, Roberts said, I think this is a terrible law, but it's clearly within the Congress's delegated powers. He said it was delegated power under tax law, not under the Commerce Clause. Be that as may, but he said it was part of it was within Congress's delegated power. And it's not for the court to say that Congress, made a bad decision. That's not the court's role. You then get to the voting rights case that talked about where they undid much of where the court held that the provision in the 1965 Voting Rights Act that required pre-clearance was unconstitutional. And that was a situation where Congress had reauthorized the Voting Rights Act about 10 years before the case in the 1990s by a vote by almost unanimously. I think the vote in the Senate was 92-8, and the vote in the House, there was only 2 dissenting votes. And here is a situation where Roberts basically said Congress didn't have the factual right to make this decision. Now, it's clear to me, at least, that in one case he's saying we're not going to interfere with the political decisions of Congress because we think it's bad law. They made the wrong decision on the facts. And here's a case where he says that we think Congress's disregard of Obama's election is so egregious that we're going to hold its action unconstitutional. Pardon me, but if I can't yell at the top of my lungs, that's the only way to explain it. It's political.
Mm-hmm.
Thank you for confirming my suspicion.
Okay.
Florence.
Who is next?
Florence, you've got to unmute yourself. Florence. Okay, go ahead.
I was raised in Syracuse, New York, where the Erie Canal
Right.
ran right through. When I was a kid, it went right through the town and later became Erie Boulevard.
Right.
But
They moved the canal.
when you're raised that way, your history is very present. And so as we were taught in school, grade school, we were taught about, we lived on the Onondaga Reservation. Essentially, Syracuse was the Onondaga Reservation. So it's, it's living history.
Yeah, it is. And last year, Susie and I took a bike trip. I've taught classes on the Erie Canal, its impact on, I've designed seminars. I taught undergraduate seminars on the Erie Canal, calling it It's Not Just a Ditch, to reflect how this one area became a microcosm of changes that happened in the United States that were monumental. The first women's rights convention was in Seneca Falls, right on the Erie Canal in 1848. It was ground zero for the Underground Railroad. It was the heartland of the Second Great Religious Awakening, which fundamentally changed American evangelical Christianity. It basically exploded the conversion to agricultural capitalism in the North, and it also, some of the major factories were in canal towns. And so this last year, Susie and I took a bike trip last September. We rode our bikes from Buffalo to Seneca Falls on the Erie Canal bike path.
Yes.
180 miles.
And the women's movement.
Yeah, right. It was in Seneca Falls, the museum. And so you see all these things happening there. And also the Great Railroad Strike of 1877 was between Buffalo, Syracuse, and Albany, were the main, were three of the main centers of that Great Railroad Strike, where the government had to take over running the railroads to keep the mails going. One of the first great labor unrests in the United States.
Yeah.
This is a fabulous area.
Yeah.
And it also created a jumping off spot for what became President Millard Fillmore.
Well, Fillmore, the Genesee River, there was a guy named Sam Patch there's a marvelous book about him. He was America's first, he was the evil Knievel of his time. And 20,000 people gathered to watch him jump off the Niagara Falls, which he did. And another 20,000 gathered to watch him jump off the falls of the Genesee in Rochester. Unfortunately, that jump killed him. He never his body was found 4 months later downstream.
Okay, there's a question from Constantine.
What?
Constantine, you had your question, your hand up?
Oh, yes.
Yeah. I had a question way back in the middle of your discussion there about what the philosophy was, that no law should be made to for the privilege of the rich. In other words, make the rich richer and so forth and so on. I think that was, I'm not
right. That was a key point in that paragraph is one paragraph out of a 19-page veto message that Andrew Jackson sent to Congress. And the message was largely written by, the first draft was written by Roger Taney.
Right, that's correct. So what comes to mind every time, and goes to Ron, every time I do my taxes, I notice that there are certain privileges granted to corporations and companies that are not granted to individuals. Is that the same philosophy? In other words, if you're an individual, you're not rich? Is that it?
Well, no, it's not that. Look, anyone who thinks our tax law is strictly to raise money is blind. Tax law is one of our primary means of expressing social policies.
Right.
Why do you think people are allowed to deduct their mortgage payments from their taxes?
Right.
There's no reason other than we want to make it be easier for people to own their own homes. So we're going to say they can deduct the taxes, they can deduct their state taxes and their mortgage taxes. Now, recently, Trump wanted to give a big tax cut to corporations, but he had to find a way to pay for it. So he's going to take some of that away. But it's all social policy.
Okay, that answers my question. Not fixed in, the philosophy is not fixed in our, I guess, political minds, if you will, that's the way we work, because obviously it's not.
It's not. Tax law is political, and taxes are created to express social policy. Why do we have deductions?
That's what I'm primarily considering. Like, for instance, as an individual, you can't take, say, your mileage to and from work where you're doing work.
Yeah, but as an individual, you got a $24,000 exemption from off the
I
top.
realize that. But one rule should be, I would think, as naively think that one rule should apply to both categories.
Actually, you can deduct your mileage as an individual. If you operate a business, you have
Thank
Schedule
you.
C,
That's
and you
what I
can
mean.
deduct your mileage.
You have to be a business or a corporation to take advantage of this.
Right, you can't deduct your mileage driving to and from work. But
Why
on the
not?
other hand, if your job requires you to use your car, other than
that's-
to and from work, you are entitled, and you don't get reimbursed, you can drive. You can
Well,
charge it.
there are other things that are unique to companies and corporations that are
true.
not. Right.
Their tax. How about just their basic their tax rate is different.
Right. Okay. So again, we anyhow, never mind. That was my question.
Okay.
Well, I have another question. I think you hit a button there by saying all law is political. And when I think about it, the interview for new Supreme Court justices, I mean, what is then really the criteria for the qualifications? I get it, there is competence there, and they are competent, but there got to be something more. There got to be wisdom, consciousness. How would you frame that? If you are in front of them and you interview people for
really
the
want to
job.
know the only criteria for appointing a qualification to becoming a Supreme Court justice is the president picks you in the Congress and 50% of the Senate will approve. Remember during the Bush Jr.'s during Bush Jr.'s second term, or I think it was, or maybe late in the first term, he had a vacancy and he nominated Harriet Mears, who was from the White House counsel's office. And the problem with Harriet Mears is that basically she was probably a nice lady, but she was deemed unqualified. And it became clear to Bush that even though the Republicans controlled the Senate at the time, he didn't have the votes to get her confirmed. Not enough Republicans were willing to vote for her, and none of the Democrats were, so he had to withdraw her nomination. But even the issue of competence, whether or not a person is deemed competent, is in fact a political decision.
Yeah, I get it. But there got to be consciousness. Otherwise, then we have all this bickering. As Louis said,
Of course we have but that's changed. It's changed where certain social issues have become dominant political issues in solidifying the Republican Party's base. Before Roe versus Wade, before the issue, and the Republicans realized that social control, issues of social control, and what were made could be used to motivate and coalesce a strong voting bloc, that then adherence to that became critical. Nixon tried to get Bork appointed, and he was rejected, as was another guy because he smoked marijuana. And we ended up and he ended up appointing Blackmun. Thinking about Ruth Bader Ginsburg was appointed, the Senate confirmed her 92 to 5 or something. And yet now you see they're on straight party lines. And that's only because a Republican is more worried about, most Republicans today, because of the way districts have been drawn, is more concerned about winning his primary election than winning the general election. And as a result, this has made Supreme Court nominations and judicial nominations much more political. And it's also because it's happened. There are times when it was. You look at the court packing plan. Not all Supreme. There were substantial minorities who wouldn't vote for Hugo Black because he was a card-carrying member of the Ku Klux Klan. But then in 1939, if you were a Southern lawyer, you had to be or you wouldn't get any clients. I just think there's no generalization because every period is different and it's always been political, just sometimes more than others.
Okay. Well, we're to about 12:05, Arthur.
Yes, I think we're about done.
Okay.
So I will see you all. I will see you all next week where we're going to talk about slavery and Dred Scott.
All
Okay.
right.
Okay.
Thank you.
Good.
Bye-bye.
Thank you.
Thank you.
Thanks, great. Thank you.
Applause.
Glad you liked it.
Yeah. Great job.
We'll see how many liked it by how many show up next week.